Well, good morning, everybody, and welcome to our most recent seminar on Brexit. This one is looking at a review from both sides of the channel. It's now 100 days since the UK officially left the EU. So now that the dust is, well, kind of beginning to settle, what's the take on Brexit in Europe? I'm delighted to welcome as our panelists today, Paul Samrah, who's our Brexit Impact Specialist, Christoph Schlotthauer, sorry, I hope I've got that right. Christoph Schlotthauer, who's the managing director of our more global firm in Paris. And they will be joined by Tim Stovold, who's our head of tax, and Richard Cummings, who's our strategic HR partner, to input on the tax and the HR angles. But I'd like to kick off first by asking Christoph to give an overview of Brexit from the French point of view, please.
Hello, everyone. Thanks, Mandy, for the kind introduction. Yes, I can give you some insight and some perception from mainland Europe and, of course, from France. But first of all, we have to recall that the Brexit is essentially a political decision and a political topic. And this has been overshadowed by discussions on economic consequences. But in the end, as you can see by the recent development in Northern Ireland, by the discussion around the Scottish election coming up, and by the discussion around vaccines, and lately around fishing rights around Jersey, it's a political topic. So what's the perception from Europe, and what's the perception from France? Yes, I have to disappoint you. Nobody cares. Clearly, it's nothing which is on the topic. Of course, we have the Corona crisis, which is overshadowing everything. But frankly, Brexit, once the deal has been signed, and you have to recall that the European Parliament just accepted the deal 1 week ago, on the 27th of April, and honestly, it's a small headline and nothing else. And the other thing you have to bear in mind, and this is a position from the French tax authorities, and so it's of course biased, but the French authorities says, well, the British people, citizens, have decided to leave the EU. They have to bear the consequences out of it, and don't expect from us as a fiscal authority in France any simpler rules or anything smoothing the deal. The rules are in a treaty, and the treaty has to be adopted and followed. So that's basically the sense. The economical consequences in the first months have been a reduce in trade, especially in January, but honestly, statistic means not a lot. We have the Corona crisis, and we have been a lot of firms making stocks and purchase before the exit, before the Brexit. So we have to wait to have a further assessment what the consequences are. So impression from Europe and France, Paul, what's the impression from the first actor of the Brexit, you in the UK?
Yes, thank you, Christoph. Yes, a typical French response to it all as a political thing, which it very much is. Well, I mean, we've had a lot to deal with, of course, on this side of the channel. Christmas Eve, Boris Johnson stood up and said he'd got a tariff-free deal. And very quickly, as soon as we started reading the text, it became very apparent that that was his last lie of the year, because of course it wasn't a tariff-free deal by any stretch of the imagination. Allied to COVID, of course, it's been a double whammy for businesses, and you know, it takes every time there is a trade agreement, there are new rules. There's all the customs formalities that businesses have had to get used to. There's safety and security data that needs to be submitted depending on the sector you're in. There's labeling and food standards, and we're learning all the time. I think some businesses have made changes to their supply chains, but is there light at the end of the tunnel? I'm not sure about that, really. The volumes of imports and exports collapsed dramatically in January. That was put down to maybe a bit of stockpiling, COVID inevitably. It has picked up in February, but the Office for Budget Responsibility over here is envisaging that in the long run, we're going to be 15% down on imports and exports. So we've had a bit of time to digest everything, and it's good that we're past the 100-day stage now. And I think some businesses are now thinking about long-term measures and thinking that maybe the short-term measures that they put in place have now filled the gap, as it were, and now they're looking more strategically as to what they should be doing, and we'll come on to the idea of overseas subsidiaries, etc. And Northern Ireland is a big mess. The Trusted Trader Scheme for businesses in GB, Great Britain, shipping goods over to Northern Ireland, that's a shambles, would be to put it mildly. And of course, as you say, Christoph, that political angle is huge in Northern Ireland, as we've seen with the political issues and ramifications still going on even now. And then you talk about Scotland as well. So yeah, a lot happening. But I think underlying all of this and buried in the trade and cooperation agreement was the wonderful line that the deal is going to be reviewed every 5 years. So, unless we build the trust and confidence between the EU and the UK, we're in for another rocky ride coming up. It's pleasing that they have actually, at last, the UK has recognised the EU ambassador, because we're now able to have a EU ambassador in residence, so that the diplomatic niceties have been ticked, and let's hope we can move forward and build the trust, because, as you say, there's still equivalence, regulation and data, key issues that are still outstanding to be resolved. There we go.
Yes. Well, thank you both. That's really interesting to kick off the session. What we're going to do is we're going to cover 4 broad areas today: people, goods, including duty and VAT, work and travel, and contracts and regulation. So let's start with people. And so the first question is, what should I do if I have EU citizens working in my organisation?
Well, Mandy, if I may answer first, you have to recall that the EU is built on principle of freedom of movement of goods and services, cash and people, and we are talking about a free trade agreement, and the free trade agreement covers goods. So there is a huge part which is left out. However, there is the possibility to work in the UK and in France for UK citizens and French citizens. And it's now up to the responsibility of the employee to make sure that he complies with the relevant rules, that he has the appropriate permit when he works on both sides. So yes, if your question is it still possible? It is. But as for many other things, the administrative burden has increased and has to be coped with, and relies heavily on the individuals who have to comply with it. I think, Paul, you can probably from the British angle elaborate, and Tim and Richard are there to second, I think.
Yeah, I think the issue over here is really for employers to be alerting their staff that they need to get the pre-settled or settled status, depending on what position they're in, by the 30th of June. And that is a key date, 2 months away, because all EU citizens working in this country must have got that status. Pre-settled if they've been here less than 5 years, settled status if they've been here 5 years, they'll automatically qualify. There is an app. It is relatively straightforward, but if they don't have that status, then the individuals will not have the immigration status and would effectively be prevented from starting a new job or retaining their existing one. I think there's no requirement, Richard, I think I'm reasonably correct on this, for employers to carry out right to work checks, because it could be viewed as being discriminatory. Is that right?
Yeah,
Richard?
kind of. Up until the 30th of June, yes, that's right. You shouldn't actually do it. But post the 30th of June, you can ask, but they're under no obligation to share it with you. However, as an employer, you do have to comply with border agency legislation, and you can't employ people who don't have the right to work here. So there's always been this kind of fight really between the border agency and the employment tribunal, because this all stems from modern slavery acts, that actually if you find somebody who's working illegally in your organization and doesn't have the correct permits, you can't just tell them that they've got to leave. You actually have to go through a process. So you should follow the process properly and then exit them from the firm.
Right. The issue of offices in France and the UK and people splitting their time across border, that's an issue, because obviously it is quite popular to be working both in the EU and within the UK. Tim, are you picking up on the tax aspects of that?
Well, yeah, I did. I had a good chat with one of my global mobility senior managers yesterday, and he said the work's shifted from all the advice we've been asked to give was all at the beginning around accidentally stranded people who'd gone on holiday or had travelled abroad and found they couldn't come back, and it's pivoted now to people realising they can work remotely. So this is now people who choose to work remotely or in multiple jurisdictions out of choice, not out of necessity. From a global mobility or an employment tax standpoint, I think employers are finding it quite irritating, because you've got one employee who chooses to go and work from their French second home, or possibly or Italian, Spain, choose whichever EU territory you like, and that brings upon the organisation the need to go and seek some quite complicated advice. Tax is almost certainly going to be due in the jurisdiction in which they're working. Who has the obligation to collect that tax? Is it an employer obligation to set up a payroll scheme, or can the employee be left to their own devices to file a tax return? Do we have social taxes? And the thing that always terrifies me, particularly about France, Christoph, is your social taxes are very high. We thought national insurance was a pain. You wait until you find out what the French equivalents are. So is your employee working in another European territory exposing you to the horrors of French social taxes or other European social taxes? So all of that advice to be taken. And then, has that employee sitting working in their holiday home in the south of France, have they created a permanent establishment for the business? So, have they created a taxable presence? Does the business now need to register with the EU, French or otherwise, tax authority to file corporate returns? And if so, I think, Christoph, and I struggled to get to the exact rate, I think the rate's 26.5% corporate tax, something like that in France, like one of the many rates. But it's what the rates I did find all seemed higher than the UK rates. So if you've got somebody who's created a taxable presence in an EU territory, have they actually not just created an irritant? You've got to take some employment tax advice, possibly pay higher social taxes, but have they also created a higher corporation tax liability for you? So, flexible working, that's fine, but work from home, come into the office when you like. Flexible working, that person working in another country, be very careful before you establish a precedent in your business to say that's acceptable, because it will create the need to take some quite complex advice.
I have to jump on this as well. So the fact is that you've got somebody working in another country and they're in a European country. What holidays are you going to give them? Just because they're working in the UK, they were working here yesterday, and you were quite happy that they were adhering to the bank holidays, also when it comes to sick pay and stuff like that. And then what happens as well, if there's a dispute with the employee and you decide that actually you need to part company, and what regulations are you doing that under? Are you doing it under the EU country that they're in, or you're doing it under UK? So, and I think, as Tim said, once you start this, you've almost it snowballs. So you have one employee, he decides to go work from Spain, and then another one who wants to work from Italy. You've now got potentially two liabilities there that weren't there before.
So the advice or the summary on this subject is, yes, it's possible, and it's more likely to happen. than before, because you can work remotely. You have to make sure that you have the relevant permit if it's for a longer period, and so the period you have to have in mind, at least for coming to France, is 90 days. If you want to work longer than 90 days, you have to apply for a long stay permit and a working permit. But the most important thing, and Tim, Richard, you stressed, is to make sure that you are not creating a permanent establishment, and then you have to comply with another set of rules. And on the other side, for the individual, if he moves from France to the UK and works in the UK, and you have to remember that London has been seen for a long time as a vibrant city where younger people would like to live and to work, then you may have a problem of an exit tax because you're leaving France and you are now have to pay social security. I understand there is not a lot in the UK compared to the horror tax in France. I quote you, Tim, and of course income tax. So there is a whole set of rules you have to keep in mind. And as you said, Richard, once you started it, be very cautious that it doesn't go in a direction you don't want to go.
Okay, well, that's a very comprehensive answer. Thank you very much indeed to all of you. What happens if we've got EU citizen employees who don't have an EU settled status on the 1st of July? What does the employer have to do?
Well, this comes down to the aspect of discrimination, and I think they just sit back and wait. Is that right, Richard?
Well, not quite.
They've got to be very careful about.
You do have to be very careful. So you can't start singling people out because, as Paul said right at the beginning, you could be discriminating against them. However, you do have an obligation as an employer to ensure that you are actually employing people who have the right to be here. So you are permitted to do checks at periodic times, and that you should continue to do so. But yes, you should check, really. But you have to check everyone. Is the answer.
Okay, thank you for that. We've got some questions coming in, which is absolutely brilliant. Just to let everybody know, we'll have time for questions at the end, so please keep them coming in and we'll pick them up. We've reserved some time today. Another question under people, last question under people. We have offices in France and the UK. Can my team still split their time between the UK and the French offices and vice versa?
I think we covered this subject. The simple answer is yes, but you have to be prudent on the impact you may have, tax-wise, social security-wise, and permit-wise. Okay,
great, thank you. Well, let's move on then to talk about goods, including duty and VAT. So the first question we have here is, will establishing a subsidiary company within the EU avoid tariffs on imported goods from the UK?
Let me start. I would say not necessarily, because what you have to check is, are the goods produced in the UK or mainly produced in the UK? So the basic rule is the country of origin, and depending where the products or goods are manufactured and what kind of products and goods we are talking about, you may be subject to a double tariffs, the ones when you import the raw material or the not finished goods to the UK, and then again if you import them from the UK to the EU. So much for the free trade and no tariffs agreement between the UK and the EU, Paul, you mentioned earlier on.
Indeed, yes. So I think that important to note that there is a distinction between the tariffs and the import VAT. You can set up a subsidiary company in the EU to be the importer, and therefore actually the VAT can be recovered by that entity, but you haven't done anything about the tariffs. Tariffs, if you are have goods, as Christoph says, that actually under the rules of origin are such that it's outside the EU or outside UK, then you're going to be in for tariffs regardless. So only by using customs warehousing or shipping direct into the EU will you avoid a double duty hit, because if you've imported goods from the Far East into the UK, there's going to be a tariff. likely. And then if you're then shipping them out into the EU, you're going to get the double hit of a duty. So in answer to the question, will establishing a subsidiary company avoid tariffs on imported goods? It depends on the rules of origin, but I suspect that if you're routing it from the Far East into the UK and out, you won't be avoiding. You would need to look at your supply chain and think about it being operated in a different way.
And Paul, if I may, just on the last sentence you said, so it's definitely a question of supply chain, because you may reroute, if you are a global company, your goods not going through the UK but directly to the EU and avoid the double tariff hit. But this, of course, opens a whole other set of questions, which are supply chain, logistical questions, and of course transfer pricing, because you have to recalibrate everything than before. So from a single question, which is VAT and tariffs related, you end up with a global supply chain question and a global transfer price issue, which is quite complex.
Yeah, and I think this is where we're getting into now, 6 months in to Brexit. The knee-jerk reaction, as I mentioned earlier, has now passed, and now we're looking at businesses that are thinking very strategically and weighing up the costs of doing these significant changes, taking their time to analyse and working through, and coming to the conclusion that yes, being the importer of record, rerouting goods in a different way may save them significant sums of money. But upcoming, we have got changes to VAT rules coming up from the 1st of July, applied to B2C sales, business to consumer sales within the EU, which will see import VAT replaced with an obligation to account for a local sales VAT, and also the introduction of a simplified customs declaration for low value consignments. We're waiting further details. Now, until the 30th of June, goods with a customs value of less than 22 euros can be exempt from VAT. However, this will change from 1st of July, and VAT will be due on all imports, regardless of value. So that's the big change, and the new one-stop shop mechanism from the 1st of July will require most online retailers based outside the EU to register for VAT. So, you know, there are issues there, VAT, and as I say, this whole Brexit saga is still working its way through, and changes are happening. Just in terms of opportunities, it might be appropriate now to think about, you know, it hasn't, I know it's been doom and gloom, but what opportunities are there for businesses? I mean, Christoph, I'm sure you're talking about other overseas markets outside the EU, reviewing the supply chain and thinking about different ways of doing it. AEO status, authorized economic operator status, is the kite mark for simplified customs procedures, and you know, the idea that your goods will be speedily transmitted across borders. That might be something to consider, but it's not easy. It's a lengthy process, certainly over here, Christoph, I'm sure in France as well, a lot of barriers to overcome, but it's worth the investment if you have got a volume of exports going across. And perhaps an opportunity to look at your systems and processes and look at digital transformation as being an opportunity for you to review your processes and think about digitalization, and looking at home markets as well, that maybe you might have other suppliers that have dropped out. There might be more competition out there. So it does throw up a number of opportunities. I think is important to remember. It's not all doom and gloom.
And Paul, you said it. There is an opportunity because the domestic markets in the UK and vice versa in the EU is maybe or seems a little bit more protected for the local producer. And on the other side, since there is a clear argument to set up a subsidiary in the EU to be present in the EU for UK businesses. Also, sometimes to avoid the administrative burdens, this creates an opportunity to be present on a local market and to expand as now not really as an exporter, but as someone who is working in the market with its own structure. So I know there has been a lot of recommendation from your own government to establish subsidiaries. I would welcome them in Europe and of course in France, you can imagine. But I think this is a clear opportunity to be present in the market and to serve the market. And it will be a necessity for service provider anyway. We know that big architecture firms, design firm, advertising agency are thinking of increasing their presence in Europe, just to be present and to participate in public tenders, big tenders, and to be perceived as a local locals, if you'd like.
Yeah.
Great, thank you. Really interesting. I think let's turn now to work and travel. And just to kick off that topic, can I still drive in the EU with my current UK driving license?
You mean with your EU driving license in the
With my
or vice versa? So my first answer would be if you know how to drive on the other side, yes. Because this hasn't changed. We still have a difference here. No, jokes aside, yes, of course, you can drive with your UK driving license for tourism or for short stay in Europe, and vice versa. You can drive with your European license in the UK. It's only if you change your country of residence that you will have to exchange your driving license. And surprisingly, I read somewhere that if you become a French resident and you would like to exchange your UK driving license, you have to pass a test. So my joke about knowing to drive on the other side is maybe not really a joke. You have to learn it. So, but for the general public, which is listening to us, if you go for traveling, you rent a car or you go there for holidays, you can use your driving license without having to have an international driving license or any translation.
I think if you're driving in the EU, you're a UK resident, you're driving in the EU, you do need to have the right insurance, the green card insurance to cover you. I think that's one of the points, but otherwise you can just drive over across the channel, avoiding Jersey at the moment. Yeah, no, that's fairly straightforward. I think that the travel documentation is really the ID cards from 1st of October. The UK has said you've got to have a passport. It won't accept a national ID card. And that's just one of their little quirks that we've put in place for anyone coming from the EU. So yes.
And it's the same on the other side. So the date you have to be in mind is the 1st of October. After the 1st of October, there are some exceptions for some professions and some special situation. You need a valid passport, and you need a passport with an expiry date, which is more than 6 months after the day when you are entering the country. And this makes a change because otherwise the travel between EU and especially through this channel was quite forward with an ID card. So look at your passport, make sure that you have a correct expiry date. So otherwise you might have a surprise in October.
Mm-hmm.
Yes. And what's a frontier work permit?
Yeah, that lets you come to the UK to work in the UK whilst living elsewhere. And it shows you've got a right to work, to rent, and also access benefits and services, including NHS healthcare, providing you meet the eligibility requirements. Richard, do you want to add anything on that?
Yeah, it's basically if you were here before the 31st of December and you don't want to apply for settled status or pre-settled status, and then you can use the Frontier Work Permit that way. Yeah, as Tim said, as Paul said, it does give you access to other benefits. It can be rejected though, so you can actually be rejected on health grounds, and so you may not be able to access the NHS. But it doesn't apply to spouses, so they would still need to apply for a separate visa. But yeah, so it's just it's an alternative to a visa and the settled status routes.
Okay.
And it's definitely something which is quite common. We have a lot of people crossing the border regularly to work on both sides, and there is a similar regulation in the EU and especially in France, where you need to apply to a specific permit as a frontier work permit. It's called Accord de retrait du Royaume-Uni, but you don't care about the right termini. You just have to know that you have to apply for this. And if you are in the situation where you are living close to a border, meaning to the channel, and working on both sides.
Understood. Okay, well, thank you very much. Anything else anybody would like to chip in on work and travel before we move on? No? Good. Contracts and regulation, I guess, is an enormous topic. What have you seen as the practical effects of Brexit on commercial contracts?
Well, Paul, if I start, what we've seen and where we urge clients to be careful is on the clause regarding the competent place of jurisdiction, which is for us something which is to be regarded carefully, because so far you could have a place of jurisdiction being the UK, and the UK court decision would be binding in other EU countries, and this is not the case anymore, or it's the case under special circumstances, and it may dilute itself over the time. So what we recommend is to look at contracts, to make sure to identify what has been stated in the contract, and to reflect if it wouldn't be more advisable to have EU located competence to settle this kind of disputes. You may know that Paris is positioning itself as a place of arbitration. There has always been a place of arbitration in Paris, but here a special place for this kind of international litigation. So once again, pay attention to this, and then of course in the contracts pay attention to any reference to EU regulation which are embedded in the contracts. One aspect might be GDPR, but it's not the only one. There are many other ones where you have to review your contract and to make sure that there is an equivalent and there is a fair understanding what you're meaning by referring to this rules.
I think also the INCO terms, the international trading terms, should be dug out and checked, because the INCO terms before Brexit were largely irrelevant because of duty, because there was no duty passing between the countries. Now, of course, if the rules of origin and other issues deem that there are tariffs, and your INCO terms reflect the fact that it's delivered duty paid, then of course you as the supplier are going to be bearing those duties. So, that's got to be renegotiated and discussed. The other issues about trading, just basic stuff, recompense for delays at ports because of incomplete customs declarations, pricing issues with the duty and possible increased travel costs and employee costs, aware of the risk, transportation issues, and generally supply chain security should all be addressed and refreshed to make sure that it's fit for purpose in the new world. So yes, mustn't forget looking at these commercial contracts.
And Paul, your last point is quite important, because we are always coming from tax and we are coming from legal requirements, but the cost for the administrative burden and the cost in timing, warehousing, shipping, and so on, who bears the cost? So the approach cost for selling across the country and the border to the UK on the other side has to be covered and reviewed in the general conditions and terms of condition of the contracts.
Yeah.
And the last point, and related to contracts, I'm sure we're going to add on it. It's of course norms, technical norms. No? We effectively, even so, the norms in the UK and the norms in the EU are the same, for the time being. Products will have to comply with two sets of norms, being the UK ones and the EU one. Once again, they are similar, identical right now. They might go apart, but at least you have to mention that you are complying to both sets of norms. And this also requires certification, requires checking, auditing, and of course, printing or providing for in the contracts.
Yeah, labelling and food standards, and we've seen issues with Scotland where food has perished, perishable goods. The delays that it takes to clear in a port has been problematic. Just moving on, I mean, maybe intellectual property, we should just quickly touch on that. Up to 31st December, it was covered within both sides of the channel, that there was protection for IP rights, and the spirit of the agreement says that the UK and the EU will protect the IP rights of each other's nationals no less favourably than their own. So that was a positive. But going forward for new IP, it's about registering it in the EU and in the UK separately. So important point there. And then maybe just touching on data flows and where we are on data. We said that equivalence and regulation and data still has to be decided upon. They seem to be nearing a conclusion on data flows, but I think they're a bit worried that the UK might change and diverge from where they are at the moment on data adequacy. But essentially, they're saying it is okay for data to be transferred across borders, but they're looking to get some sort of clauses in to protect if the UK diverge, and that they would actually be able to repeal the agreement. So watch this space, but at the moment there has been no real change in data flow regulation. I think that
Paul, you've seen that this topic has to be re-regarded again in 4 years.
Yes.
So as you said in your intro statement, we may have reached an agreement. We clearly have teething problems. We are getting astonished to, or at least we are getting around them. But we all know that there is a clear deadlines where we have to review all the agreements, and then possibly we will start to have a discussion again.
Yeah, and it's building that trust up and agreement. It doesn't help with today's news, certainly with fishing rights being really and truly. It's just why is fishing rights have always been the big issue for the UK? Maybe because we're an island, I don't know, but honestly.
I think so.
Yeah. Yes, I thought we might manage to dodge talking about Jersey fishing, but, but I realise
there's always a place for that.
There's always a place for talking about fishing in Jersey. Listen, thank you very much. That, really helpful updates. We've got a few questions, quite a few questions. And Tim, I notice, has been diligently answering some of the tax questions as we go. As usual, we'll circulate answered questions after the webinar. So if you just feel comfortable that that's going to be coming around along with a recording of the webinar. But let's move now to the questions. First one is looking at duty and VAT. How do we deal with import duty and VAT incurred from delivered goods, DDP, to EU countries?
Right, well, certainly you need to establish who is the importer of record. And the importer of record would be required to settle the VAT. The import duties would have to be paid because it's DDP, so they're paid up front by the supplier, and you just need to establish an importer of record who is going to pay the VAT and be able to recover it. But of course you need to have established what entity is going to be the importer of record.
Yeah, okay. Thank you, Paul. Another question on goods tariffs. Can you explain again on which kinds of goods tariffs will be payable, although we have a tariff-free Brexit deal?
Well, essentially, goods created in the UK and UK sourced are effectively tariff-free. But if you're buying from outside the EU and bringing it into the country and only slightly modifying it, very little processing, then you have got a problem, because you will be paying a tariff on the way in, and if you're then shipping it out to the EU, you're going to be faced with another tariff. So this tariff-free heading only applies if the goods have been EU or UK produced. There was an issue, you might have heard of the Percy Pig issue with Marks and Spencer's. Marks and Spencer's imported Percy Pig sweets made wholly in Germany. So on import into the UK, absolutely fine, there is no tariff. But then they were shipping them out, the Percy Pigs, to the Republic of Ireland. And that's where the problem came, because they were shipping goods that had not had any added value from the UK at all, and therefore there was a tariff, and that hit the headlines. So in broad terms, and the rules of origin, which you might have heard that expression a number of times, that's all about how much of the product is manufactured either in the UK or in the EU. And you can look up the specific tariff code and check what the rule is. The rule will be different for each different supply.
That's the most important thing. You have to check product by product type, because the percentage that can be manufactured outside of the EU and outside of the UK will be different product for product, and deciding what kind of tariffs you have to pay, or if you have to pay a tariff or not.
Yeah. Yes, it's not straightforward, but thank you very much. That's much more understandable now. Still staying for the moment with moving goods around. If I'm buying product from Ireland, which then gets shipped direct to another EU country, do I need to be VA registered in Ireland or the receiving country to avoid VAT, European? Yeah.
Well, Republic of Ireland is in the EU.
Yeah.
So the aspect of going from Republic of Ireland into the EU is not of significance, because you're actually effectively dealing with an EU country in the first instance. And on that basis, you would probably need to be registered in Republic of Ireland at the first stage.
Okay.
So sorry, I've just got a question. So on the Percy Pig point then, if it went from the Republic of Ireland to France, but via the UK, then that would be a different story, because it'd all be VATable.
Say that again.
So if it went from the Republic of Ireland to the UK and then straight to France without any alteration to it at all, that wouldn't be as simple.
No, you've just changed the country. You've just changed Republic of Ireland to Germany, and then out into the UK, and then out to another EU country. You haven't changed the overall model. You've created it within the EU, it's come into the UK, and it's gone back out to the EU. The issue is that the UK hasn't added any significant value to that product in the intermediate stage, and therefore that's why there is a tariff.
Right.
So the way to avoid it is to ship directly from Germany to Ireland, or in your example from Ireland to France, and do the labeling, what Marks and Spencer is doing in the UK, in Ireland or in France. And this is why you need a subsidiary somewhere to do it.
Well, I was going to say that's precisely why the UK government and the CBI and goodness knows who else is saying that the way around this is for all British companies to set up UK subsidiary, EU subsidiaries, possibly an unintended consequence of Brexit, who knows. Okay, another question here on retail this time. One-stop shop only applies to online retailers. As a business which also sells on eBay, am I required to register for one-stop shop scheme, or will eBay do this? We may not know the answer to that question.
eBay will do very little, and they certainly won't help. eBay and Amazon are just washing their hands of it all. I suspect you will be required to register for the one-stop scheme. Effectively, yeah. I'm sure.
Paul, I don't have the answer, but I can only say from experience that they won't help, and they will even put the burden on you as a seller to show that you're complying with the rules. And otherwise they will kick you out. So on online businesses, Brexit has a real consequence.
Yeah, for sure. Okay, we talked a little bit about food labelling. So we may have sort of touched on this one already, but how are UK businesses dealing with food labelling EU requirements, i.e. products needing to have an EU address?
They're having to get an EU address to put on their labels, on their labels and on their products, and that's, you know, effectively having a sympathetic, friendly person over in the EU that will be the office to receive any correspondence. It's a pain, but it has to be done. Yeah.
Okay. Well, still sticking with the import and export and goods and duty, other than subsidiaries created in EU countries, what else can be done to reduce or avoid VAT and import charges when shipping to the EU? I suppose, if anything, is something to add to that.
Well, what can be done to reduce or avoid? Well, reducing, I mean, it's two separate things, VAT and import charges. Let's deal with the import charges, or tariffs or duties, whatever you want to call them. That clearly is about rules of origin and your supply chain routing. So looking at that as a separate exercise is key to whether or not you can mitigate your tariffs. It may well be that you can do some additional processing that will transform the product and therefore get you a reduced tariff. And look at the rules. Make sure you've got the right commodity code, as Christoph was saying. You know, make sure you've got the right commodity code, so you're looking at the right rule. So that's the duty, and the VAT. You need to be the importer of record. You know, the importer of record will be able to reclaim that VAT, the import VAT, and you need to have the appropriate vehicle to do so.
Okay, thank you. Again, I think we've sort of touched on this already, but just for the sake of not leaving anyone hanging, if my company were to set up a subsidiary in Ireland but export to France from the UK, when the goods arrive in France, can I use the Irish EORI number to not pay VAT?
Yes, because it would be the Irish company that would be selling on. Yeah.
Yeah.
That would be the Ireland to mainland Europe would be an EU transaction.
Paul, under consideration that the goods are really sold by the Irish company and shipped by the Irish company. So this, I mean, the logistical and factual movement of the goods have to be in line with what you are declaring.
Yeah.
Yeah. Okay, thank you. There is an elephant in the room question. No mention of financial services, which of course is you know, a much bigger area than goods. I think that's yet to be agreed, isn't it, Paul?
Yeah, I mean, in terms of regulation and equivalence, yet to be agreed. But services in the B2B sector, that's been the least affected by Brexit. Whilst the underlying legislation has changed somewhat, the basic position is that those businesses have traded the basis that they don't charge VAT to overseas customers remains the same. Yes, in terms of the actual transaction and the regulation, that's all up in the air. But in terms of the VAT aspect, nothing much has changed.
No. Okay. Well, yeah, and I guess it's watch this space on things like passporting, etc.
Yeah, and we'll be back in 4 years' time to look at what is coming up with the review.
I suspect that we may need to come back and revisit some Brexit impact as more comes out of the woodwork over the next 100 days or so.
Yeah.
Tim has once again been diligently answering questions, which means the last questions that we had on there have disappeared. So I think that brings us to the end, unless anybody else has got some final questions for our panel while we've got, you know, such a fantastic range of knowledge available.
No.
Okay, well, listen, that was absolutely fascinating. Thank you so much. It was really interesting as well to hear straight from Paris, the French and EU perspective on this. So, Christoph, particular thanks to you for joining today. Really, really interesting. Thank you very much to everybody in the audience for this webinar for joining. We will be sending out a link to the recording, a copy of the Q&As, and as when you get that, and indeed when the webinar ends, there'll be a quick pop-up just asking you to give us some feedback. And as ever, it's so incredibly helpful if you just spend, you know, 1 minute doing that. We'd be really, really grateful. Please do join us for our next webinar, which will be on contractors and IR35, and that will be on Thursday, the 20th of May. But in the meantime, huge thanks to our very clever panelists.
Thank you very much.
Bye-bye.
Bye-bye.
Bye-bye.